The House Judiciary Committee chamber erupted in tension as Kash Patel, the former Trump administration official and current conservative media personality, leaned forward into his microphone with that familiar combative expression that had defined his political career. What had begun as a routine oversight hearing on federal law enforcement had suddenly transformed into a high-stakes confrontation between one of Trump's most loyal defenders and one of Congress's sharpest legal minds. Representative Crockett. Patel's voice dripped with condescension. What we're witnessing here is a perfect example of how Democrats twist the law to serve their political agenda. You're not interpreting federal statutes. You're manipulating them to attack your political opponents. That's not legal analysis. That's political theater masquerading as constitutional scholarship. The accusation hung in the air like a challenge. Kash Patel, the man who had spent years defending Donald Trump's most controversial legal positions, was now questioning the legal credibility of Representative Jasmine Crockett, and he was about to discover exactly why that was a catastrophic mistake. What Patel didn't understand in that moment was that he had just challenged someone whose legal expertise would make his own background look embarrassingly superficial by comparison. In the next 10 minutes, the political world would witness one of the most devastating intellectual takedowns in recent congressional history. A systematic dismantling of political rhetoric by constitutional precision. But there was something about this particular exchange that nobody in that committee room could have predicted. Something that would explain why legal scholars across the country immediately began sharing video clips of what was about to unfold. Why constitutional law professors started clearing their afternoon schedules, and why this committee hearing would become required viewing for anyone interested in the difference between political posturing and genuine legal expertise. If you want to understand exactly how a Harvard law graduate systematically destroyed a political operative's credibility using nothing but legal precedent, constitutional analysis, and devastating intellectual precision, you need to hear this story from the beginning. Because what unfolded wasn't just a political moment. It was a masterclass in how rigorous legal training can triumph over manufactured authority. To appreciate the extraordinary nature of this intellectual confrontation, the foundation of the two dramatically different individuals at its center, and the collision between political opportunism and constitutional expertise that made this moment inevitable, must be understood. Kash Patel had meticulously built his public profile as a figure of unshakable loyalty. A reliable defender of the conservative cause during the most legally controversial periods of the previous administration. Born with the intent to climb the rungs of influence. His legal education, a product of the University of Richmond School of Law, served primarily as a credential. He leveraged a stint as a federal prosecutor not into a career dedicated to objective justice, but into a launchpad for Republican politics. His ascent was swift, culminating in a significant role as a top official within the Department of Defense during the administration's turbulent conclusion. Patel's professional reputation was not built on nuanced legal theory or complex statutory interpretation. It was built on political aggression and an unwavering, almost absolute, fidelity to partisan objectives. His approach to legal dilemmas was consistently informed by political necessity, prioritizing messaging and alignment with his audience over analytical sophistication. His effectiveness, as noted by former Justice Department insiders, lay in his singular ability to distill intricate legal matters into easily digestible political talking points that resonated fiercely with his base. He was skilled at borrowing the credibility of his legal background to legitimize arguments that frequently lacked rigorous legal foundation. Patel's confident attack on Crockett was rooted in the misassumption that the committee hearing was merely another stage for political performance, where rhetorical flair outweighed scholarly depth. His knowledge of Crockett appeared limited to the superficial, partisan media narratives, leaving him entirely unprepared for the sheer volume and intellectual density of the legal expertise he was moments away from encountering. Yet, seated directly across the dais was Representative Jasmine Crockett, representing Texas's 30th congressional district, a presence that signified not mere political ambition, but the culmination of a decade of relentless, rigorous legal and constitutional scholarship. Crockett's path was defined by the deep-seated conviction that constitutional principles only hold true value when they can be effectively deployed to protect real citizens facing the real weight of the legal system. Her background, rooted in working-class experiences, instilled in her the belief that legal knowledge was a fundamental instrument of justice, not a tool for political gamesmanship. Her academic journey was exceptional. She earned summa cum laude honors from Rhodes College, followed by a distinguished tenure at the University of Houston Law Center, where her analytical prowess was immediately evident. She was not simply a capable student, she was a published legal thinker, with law review articles on constitutional interpretation cited before she even received her degree. The final seal of her expertise was etched at Harvard Law School, where her Master of Laws, LLM, focused specifically on the critical nexus of constitutional law and federal criminal procedure, the exact areas Patel was now recklessly challenging. Her master's thesis, a deep dive into prosecutorial discretion and its constitutional limits, was deemed so essential that it was published and continues to be referenced in federal court cases involving criminal procedure. Constitutional experts universally recognized her unique threat profile to political operatives. Her combination of theoretical constitutional understanding, backed by extensive, practical courtroom experience, made her formidable. Crockett did not just memorize the Constitution. She had successfully applied it in complex federal litigation against some of the country's most seasoned prosecutors, particularly in the realm of challenging prosecutorial misconduct and upholding civil rights. The hearing that served as their arena was focused on the oversight of federal law enforcement, specifically addressing persistent allegations of partisan influence and politicization within the Department of Justice's charging and investigative mandates. This was precisely the kind of dense, complex legal and constitutional territory where Crockett's expertise was not merely valuable, but absolutely vital. Patel, invited as a partisan witness, was there to aggressively defend the past administration's approach to law enforcement, while Crockett, as a committee member, was poised to interrogate those policies through the lens of constitutional integrity and prosecutorial accountability. The tension had not simply been building, it had been meticulously engineered by Patel throughout the morning. His testimony had been overtly aggressive, designed to provoke political counterattacks rather than facilitate substantive policy debate. His political combativeness was a challenge in itself. What happens when pure, unalloyed political rhetoric is forced into direct collision with meticulous, unwavering legal analysis? The critical inflection point arrived when Crockett began her line of questioning. Her tone measured and professional, devoid of the partisan fire Patel expected. Her inquiries were not broad political jabs. They were technically sophisticated and laser-focused on the specific constitutional principles and legal standards governing prosecutorial independence. The initial query was a precise opening salvo, demanding Patel's familiarity with the constitutional framework established by Morrison versus Olson, specifically concerning the limits of political interference in prosecutorial independence. Patel's response immediately betrayed his strategy and his shallow legal engagement. He entirely sidestepped the Morrison versus Olson precedent, opting instead for the generalized political argument: the president, as the chief law enforcement officer, possesses the constitutional authority to set all law enforcement priorities. It was a politically satisfying answer that conveniently ignored the intricate legal constraints governing the issue. Crockett's immediate follow-up was lethal in its precision. Refusing to allow the evasion, she pressed him, reminding him that Morrison versus Olson was not about broad executive authority but about the constitutional limits placed on that authority, the necessary degree of independence required to maintain legitimacy. But Patel had no interest in engaging with constitutional nuance. He sought the immediate political victory. He chose to escalate, launching the frontal accusation that she was twisting the law and engaging in mere political theater. The chamber atmosphere solidified. Patel had just committed a profound error, accusing a Harvard-trained constitutional attorney, publicly and without merit, of legal malpractice. Crockett paused, her expression transitioning from professional interrogation to one of measured, devastating clarity. Her voice, when she finally spoke, was calm, perfectly professional, and imbued with an intellectual authority that Patel could never manufacture. The time for political sparring was over. She accepted his challenge, declaring that since her understanding of constitutional law had been questioned, she would now provide a real-time, rigorous demonstration of precisely what legal analysis should look like when applied to the core issues of prosecutorial accountability. She opened her folder. The documents were not talking points, they were legal precedents. The show was over. The masterclass was about to begin. She started not with a political rebuttal, but with the fundamental constitutional bedrock, the principle established in Morrison versus Olson. Tracing its development through decades of Supreme Court jurisprudence, the intellectual dismantling of Kash Patel had officially commenced. The committee room had ceased to be a venue for policy oversight and had been transformed into an appellate court where the stakes were not just legislation, but the very credibility of political engagement with the law. Kash Patel, leaning back with a forced, defensive smirk, watched as Representative Crockett executed the first phase of her legal counterattack. It was an intellectual deployment, strategically organized to leave no doubt as to the superficiality of his earlier dismissive accusations. She began by establishing the unassailable foundations of the legal system, asserting that the constitutional framework governing prosecutorial power was neither negotiable nor subject to partisan political revision. Crockett's opening salvo was not a mere recital of case names, but a precise, real-time application of jurisprudence. She meticulously explained that the foundational principle established by Morrison versus Olson defined the prosecutorial function as a core executive duty that, nonetheless, carried an inherent constitutional requirement for protection against political interference. She didn't just cite the case, she drilled down into the substance of Justice Rehnquist's majority opinion, highlighting the explicit acknowledgement that while these functions operate under executive authority, they must operate within constraints designed to immunize law enforcement decisions from political manipulation. The level of detail was staggering, providing specific references and textual analysis that instantly separated serious legal scholarship from partisan recitation. Patel's attempt to frame the discussion as an academic legal theory was immediately rendered ludicrous. Crockett moved with devastating precision to the next layer of precedent, demonstrating the evolution of the court's thinking on executive independence. She introduced Young versus United States, emphasizing the court's mandate that prosecutorial discretion must be guided solely by the public interest and the merits of the case, unequivocally barring decisions rooted in partisan objectives or political loyalty. She clarified that the principles she was detailing were not abstract concepts debated in lecture halls, but were binding, living law that dictated the ethical and constitutional boundaries for federal law enforcement every single day. The constitutional framework, as Crockett presented it, was relentless. She continued by weaving in United States versus Nixon, specifically addressing the court's powerful declaration that prosecutorial decisions must remain absolutely free from political control or external influence to maintain the fundamental legitimacy and integrity of the constitutional system itself. She highlighted Chief Justice Burger's assertion that this independence was non-negotiable. She then brought the discussion into the modern context with Department of Homeland Security versus Regents of the University of California reaffirming the principle that major executive decisions, including those of the Department of Justice, must be based on a foundation of reasoned analysis, stripping away any pretext of justification based purely on shifting political winds. Patel's confidence visibly eroded. The realization settled in that Crockett was not engaging in the expected political food fight but was conducting a systematic, intellectual dissection of his entire legal premise. The sheer volume and technical accuracy of the precedents she cited demonstrated a level of expertise that reduced his earlier claims of legal twisting to the sound of an empty gong. His political arguments, based on broad assertions of executive power, were now exposed as legally inadequate. Having failed to even acknowledge the established constitutional boundaries she was now meticulously charting. With the legal scaffolding firmly in place, Crockett delivered the surgical strike. She returned to the core of Patel's accusation, the challenge to her interpretation, and inverted the pressure. She did not defend herself, she invited him to engage. She challenged Patel, directly and professionally, to specify which aspect of $Morrison versus $Olson $Young versus $United States or $United States versus $Nixon he believed she had misinterpreted. This move was devastating. It stripped him of his political shield and compelled him to demonstrate his own claimed legal authority by engaging with complex, established constitutional law. Trapped, Patel fell back on the very rhetoric Crockett was dismantling. He attempted to pivot, dismissing the precedents as mere, academic legal theories, and retreating to vague pronouncements about the real-world responsibility of federal law enforcement. This deflection served only to underscore the poverty of his legal position and the stark difference between genuine constitutional expertise and manufactured political authority. Crockett countered his evasion with a calm, absolute finality. Constitutional law is the foundation of the legal system, and the cited cases constituted binding precedent. If he disagreed with their application to current practices, he was required to provide a competing constitutional analysis, not a political talking point. The transition to the third phase of her attack was seamless. She opened a final, detailed folder, signaling her shift from establishing the legal framework to applying it to the specific allegations being reviewed by the committee. Her voice remained perfectly measured as she began to detail how the constitutional standards she had just outlined, the very standards Patel had failed to refute, applied directly to the claims of politicization within the previous administration's Justice Department. She asserted that the evidence suggested numerous prosecutorial decisions were influenced by political considerations rather than legal merit, and that under the clear standards established by Morrison and Nixon, such political manipulation constituted a clear violation of prosecutorial independence. The intellectual battle had moved from theory to evidence, from abstract principle to concrete constitutional violation. The atmosphere was thick with the weight of specific, damning detail. Representative Crockett had moved past the abstract legal framework and had begun the process of tying constitutional precedent directly to the allegations of political misconduct. Her voice maintained its steady, controlled professional cadence, a deliberate contrast to the aggressive, emotional rhetoric Patel had employed. She presented documentation, internal communications and memoranda that suggested charging decisions in several high-profile federal cases were actively discussed with political operatives before the career prosecutors finalized them. This, Crockett asserted, was the clearest possible constitutional line violation. She invoked the Supreme Court's analysis in Morrison versus Olson, reiterating the fundamental principle that the input into a prosecutorial decision must remain free from political bias. When the internal record showed political staff actively participating in or influencing the decision-making process, the constitutional requirement for prosecutorial independence was fundamentally breached. The technical specificity of her argument was relentless. Crockett was not merely quoting text. She was demonstrating the highest tier of legal analysis, the ability to apply complex, established precedent to specific factual scenarios. She pointed out that the violation was particularly egregious in documented instances where prosecutorial decisions, such as the timing of an indictment or the alteration of charges, were demonstrably delayed or changed following partisan consultations. She then deployed the holding from Young versus United States, which explicitly mandates that the timing and substance of these decisions must be based on legal considerations, not political convenience or expediency. Patel's response to this direct, evidence-based application of law was telling. Forced to address specific facts rather than generalized political grievances, he offered a weak defense, attempting to normalize the misconduct. He argued that the activities Crockett was describing were simply normal coordination between different parts of the executive branch. In his view, there was nothing inappropriate about ensuring that law enforcement priorities align with administration policies. It was a desperate attempt to frame the unconstitutional interference as routine interagency dialogue. Crockett met this evasion with surgical precision. She immediately countered that Patel's definition of normal coordination was precisely the kind of political interference that Morrison versus Olson explicitly held to be constitutionally impermissible. She stressed that the Supreme Court had definitively rejected the notion that prosecutorial decisions could be subordinated to broader political objectives or policies. The constitutional structure established clear, independent lanes for these functions. With every case she cited, every internal document she referenced, and every principle she applied, Crockett hammered home the same core legal truth: the framework governing prosecutorial independence is unambiguous. Decisions must rest on legal merit, not political alignment. Any alteration or influence based on political input constitutes a fundamental breach of the rule of law. The exchange continued for several more minutes, not as a political debate, but as a systematic exhibition of legal rigor. Each of Patel's generalized, politically charged assertions crumbled instantly under the weight of her specific case citations and unflinching constitutional analysis. The legal inadequacy of his position was now clear not only to the members of the committee but to every legal expert watching the proceedings. The committee session adjourned, but the intellectual shockwave was just beginning to reverberate. The immediate aftermath of the exchange between Representative Crockett and Kash Patel was unprecedented in its velocity and intensity within the legal community. Legal scholars, who had witnessed the full exchange, instantly recognized it as a singular event, not merely a successful cross-examination, but an extraordinary masterclass in applied constitutional law. Within hours, the academic reaction was overwhelming. Constitutional law professors began sharing, analyzing, and debating the video clips across professional forums and social media. The consensus was immediate. Crockett had successfully conducted a systematic intellectual takedown of political rhetoric using nothing but the force of legal precedent. Professor Lawrence Tribe, a towering figure in constitutional law, declared on social media that Crockett had delivered a definitive masterclass on constitutional law and prosecutorial accountability, emphasizing that her presentation was the definitive example of rigorous legal analysis applied to questions of executive power. This sentiment was echoed by others across the political spectrum. Professor Erwin Chemerinsky highlighted the crucial distinction the exchange revealed: the difference between constitutional expertise and mere political rhetoric. He praised Crockett's analysis as representing genuine, serious legal scholarship applied directly to pressing constitutional questions. Critically, even prominent conservative legal scholars found themselves compelled to praise Crockett's performance. They acknowledged that, irrespective of one's partisan leanings, her legal analysis demonstrated an unquestionable mastery of constitutional precedent and prosecutorial law, the very kind of expertise required for effective, substantive congressional oversight. The contrast with Patel's defense was stark and politically ruinous. Legal commentators noted that when confronted with intricate constitutional analysis, Patel's automatic response was to launch a personal attack on Crockett's credibility rather than engage with the legal precedents themselves. This pattern exposed his legal background as wholly insufficient for the profound constitutional questions at the heart of the oversight hearing. The National Law Journal published a scathing editorial titled, "When Political Rhetoric Meets Constitutional Expertise," arguing that Patel's baseless accusations had been profoundly inappropriate and that Crockett's response was a vital demonstration of the necessity for rigorous legal analysis and legislative scrutiny. Political strategists immediately grasped the broader implications. Crockett had effectively demonstrated that genuine constitutional expertise could function as a powerful, neutralizing weapon against political attacks. Patel's aggressive approach had backfired spectacularly, revealing the critical limitations of his own grasp on the legal issues he was tasked with defending. For the Democratic side, the moment was a powerful validation of their methodical approach to oversight, one rooted firmly in legal analysis and constitutional principles rather than reactive partisan aggression. Crockett's detailed, systematic dismantling provided a clear, effective template for responding to accusations of political manipulation, forcing the focus back onto the rule of law. The exchange also dramatically underscored the essential role of specialized legal knowledge in congressional oversight. Crockett's ability to move seamlessly from abstract constitutional theory to specific factual evidence proved that effective scrutiny requires far more than political combativeness, it demands a rigorous, expert understanding of the complex legal frameworks that define and govern executive branch conduct. Conversely, for Republicans, Patel's transparently poor performance undermined their broader narrative concerning prosecutorial politicization, making their claims appear legally unsupported and intellectually weak. The encounter had instantly elevated the expected standard of legal discourse in congressional forums. The long-term implications of the Crockett-Patel exchange extended far beyond the confines of the oversight hearing, initiating a subtle but significant shift in the landscape of American political and legal discourse. Representative Crockett had not simply won an argument, she had established a powerful new benchmark for intellectual engagement in the political arena, demonstrating with undeniable clarity that constitutional expertise could triumph over manufactured political authority when wielded with confidence and preparation. For the Democratic side, the moment was transformative. It offered immediate validation of a strategy that prioritized deep, substantive legal analysis over reactive partisan combat. Crockett's systematic dismantling of Patel's arguments provided a powerful template for how to respond to conservative accusations of legal manipulation, by forcing the debate onto the objective, verifiable ground of constitutional precedent. Democratic leadership began to publicly emphasize rigorous legal expertise as an essential qualification for political leadership, seeking to position the party as the staunch defender of the rule of law and intellectual rigor. Conversely, the exchange created immediate and profound problems for Republican strategists. Patel's demonstrably poor performance had rendered their broader argument concerning the politicization of the Justice Department vulnerable and intellectually weak. His inability to engage with Crockett's constitutional analysis on its merits undermined conservative credibility on critical law enforcement and executive power issues. It forced a difficult realization that political rhetoric alone was insufficient when faced with an adversary equipped with genuine, specialized legal knowledge. The cultural impact was equally significant. Law schools reported a noticeable surge in student interest in courses focusing on prosecutorial accountability and constitutional law, viewing Crockett's performance as an inspiring example of how legal scholarship could translate directly into political effectiveness. Legal clinics noted an increased demand for the kind of rigorous constitutional analysis that she had showcased. The moment effectively made specialized legal expertise a more valuable political commodity. For Crockett, the exchange validated her entire approach to public service, a philosophy that inherently linked rigorous legal training with effective political communication. She had definitively shattered the notion that constitutional scholarship was an abstract, separate pursuit, proving instead how deep legal expertise could dramatically enhance, rather than undermine, political impact. Her staff's methodical preparation, assembling detailed constitutional analyses covering every aspect of executive power and prosecutorial independence, had proven to be the decisive factor, allowing her to instantly redirect the conversation from defensive posturing to substantive legal scrutiny. Legal communication experts immediately began studying Crockett's technique, briefly acknowledging the political attack before immediately pivoting to an overwhelming demonstration of superior legal competence. This method became a standard model for effective legal advocacy in high-stakes political contexts, demonstrating the power of intellectual confidence and preparation against improvised political rhetoric. The message resonated globally. Comparative constitutional scholars noted that Crockett's response was a critical example of how expert legal analysis can function as a crucial check on political manipulation within democratic governance. The consequences of the confrontation continued to ripple outward, establishing a fundamental change in expectations for political discourse and democratic accountability. The moment Kash Patel leveled his accusation would forever be remembered not for his rhetoric, but for the immediate, definitive scholarly response it provoked. The professional legal community rallied around Crockett's demonstration. Bar associations across the nation incorporated the Crockett-Patel exchange into their continuing legal education programs, utilizing it as a powerful case study in the effective application of legal advocacy under extreme political pressure. The American Bar Association recognized the performance as embodying the highest ideals of legal advocacy, stressing how technical legal training could be directly utilized to protect democratic institutions and uphold the rule of law. This professional validation further encouraged lawyers to view public service as a natural and necessary extension of their legal calling. Political communication strategists began integrating Crockett's technique into their training programs, teaching political clients how to leverage legal expertise effectively. The strategy was simple but powerful, transforming defensive moments into educational opportunities by using constitutional analysis to demonstrate clear intellectual superiority. This provided a compelling framework for challenging complex legal arguments while strategically positioning the Democratic Party as the intellectual defender of constitutional principles. Media coverage also underwent a noticeable shift. Journalists began seeking out constitutional experts more frequently to provide nuanced analysis of political controversies. Recognizing that political issues often contained complex legal questions that required expert context beyond mere partisan commentary, major news networks increased their allocation of airtime to legal analysis, hiring additional constitutional law experts as regular commentators. This change reflected a growing public appetite, and a media recognition, for serious, accessible constitutional analysis within political reporting. Academic institutions responded to the increased demand for legal and political integration. Universities began developing specialized programs that combined legal education with political science training, aiming to cultivate future leaders who could effectively navigate and integrate both legal complexity and political reality. The Crockett model emerged as a template, proving that legal education and political engagement were mutually reinforcing forces. Patel's accusation of twisting the law was ultimately revealed not just as a miscalculation, but as a critical error that triggered its own spectacular repudiation. Crockett demonstrated that legal expertise is more than just knowledge of precedent. It is the ability to apply complex legal frameworks to real-world political questions and defend constitutional integrity against partisan distortion. The exchange that began with an attempt to discredit her legal standing culminated in a definitive masterclass on why constitutional knowledge matters, and how analytical rigor and preparation will always triumph over manufactured political authority. The day Kash Patel challenged Representative Jasmine Crockett's legal mind was cemented in history as the moment constitutional scholarship unequivocally reclaimed its essential role in effective, rigorous democratic accountability.